It's Around the Horn.
Hey everyone, welcome to this edition of the Shenandoah PA Around the Horn. Today we're going to focus on a medical topic instead of sports, specifically the Patient Self-Determination Act. So before we start our first round of discussions, we're going to introduce our cast. Okay, first up we have Sarah Cabrices. I don't know if you guys know this, but she just got a puggle. Its name is Gigs. Oh wait, she's told everyone. Up next we have Kim Hayden, also known as the Grim Reaper. Alright, now we have Lauren What's the Gold Standard Bogar. Alright everyone, this is Emily. Chelsea won a Cracker Castle. She may be small, but this girl is deadly. And last but not least, we have Chelsea, don't feed me crackers, McCluskey, or else. Okay everyone, so this is how this game works. For each round, we're going to decide how many points each player gets depending on what they say. If they say something I agree with or that I think is enlightening, I'm going to give them positive points. And if they say something stupid or they're taking too long to say something, then they'll get negative points. Really, the points don't matter. It's just about how they deliver the information. So for the first round, what we're going to talk about with the Patient Self-Determination Act is what it is, why we need to know about it, and why anyone cares about it, and how it's impacting PAs, physicians, and patients in general. So I guess whoever wants to start, let's talk about what it is.
Well, Maddie, the Patient Self-Determination Act was put into place so that patients can decide what type of care they want at end-of-life stages or if they want care at all. So they can do this by either creating a living will, or an advance directive, or they can assign a healthcare power of attorney. Basically, this was put into place because of a woman named Nancy Cruzan, who was in a motor vehicle incident in the 80s. And after a few years of being in a comatose state, her parents wanted to take her off of life support. So they went through a lot of battles with the courts, and finally, when witnesses came forward to present information stating that these were her prior wishes, that she would not want to live in a comatose state, they put this law into effect to protect patients and their rights at end-of-life stages.
Okay, Lauren, you did a really good job explaining what the Act is, but what would be one main take-home point that you could give to the audience about how this affects future providers?
Okay, Maddie, that's a great question. So basically, all providers are required to educate their patients about advance directives. In fact, if a provider is receiving Medicaid or Medicare funding, they can actually lose their funding by not educating their patients about it. So it's something that everyone needs to be aware of. And if you've ever went to the doctor's office and you've had them ask you about it, that's why they're doing it. It is now a requirement.
Thank you, Lauren, for telling us what the Patient Self-Determination Act is. But more importantly, who does this impact? This impacts, firstly, the patients. Patients who are going from curative to palliative care, they need to start thinking about their future and how they want their health care to go. So this can be very difficult for them to sit down and think about. Secondly, it affects the institutions that accept funding from Medicare and Medicaid. They need to educate the patients on advance directives, which changes how they work in their practice. Thirdly, it affects physicians because the physicians need to talk about the advance directives with the patients, and their care is dictated by the advance directives. It also affects the nursing staff in case they're there in the situation where the patient could be resuscitated or not. Lastly, and something that people often forget, is it affects the patient's family. Their family might want something different than what the patient wants near the end of life, or the patient's family members might disagree amongst each other. So those are all people who it impacts.
Well, you see, Sarah, I have something even more important to say about it. It was proposed by Senator John Danforth, who everybody knows, and it was passed in October 26th, 1990, and it actually became effective December 1991, so a year later, and that's important to know. And since you all said everything that I think about it, I have nothing else to say.
Okay, these are all great points that you guys are making, but I think it's also important to talk about who's enforcing this law. And so when we're talking about that, we have a federal and a state level of this law. And according to the federal law, all healthcare institutions that are receiving Medicare or Medicaid reimbursement must adhere to written policies with respect to advance directives. So certain conditions that fall under this law include things like documenting whether the patient has an advance directive. Also, providers are entitled to giving information to their staff and their patients about advance directives. And if any of these conditions aren't met, then they have the chance of getting their funding taken away from them for Medicare and Medicaid services. So in order to enforce this law, things like the Federal Department of Health and Human Services are conducting public education campaigns to ensure that everyone is aware of advance directives, why they're there, and what their purpose is. Under state laws, there are similar traits that are across the board in all states. Things like individuals have the right to accept or refuse medical or surgical treatment, and then providers, some states also allow them to refuse to follow that advance directive that individual has written up.
Okay, so before we go any further, we need to discuss what an advance directive is. Basically, an advance directive is just very specific information about a patient and what they want at end-of-life care or when they're incapacitated and can't make decisions for themselves. So this doesn't just apply to elderly people, but it can apply to anyone who wants to have these decisions made. There's three parts. First is a living will, which are the actual medical information and directions that the patient wants. The second is a medical power of attorney, and that is someone that they appoint as their agent who can make decisions for them if they're not able to make them themselves. And lastly, it's a DNR order, and it basically just states whether or not you want a DNR or you do not want a DNR. So just to make things a little bit more simple as we move on with our discussions.
Yeah, thanks for all that information about the federal law. So I'm going to talk some more details on the state laws. And so for Virginia in particular, since our school is in Virginia, Virginia does recognize the patient's right to accept or refuse treatment, which is the point of these advance directives. Some of the main points for Virginia is that when you make an advance directive, you have to have two witnesses, and they have to be at least 18 years old. It can be relatives or your agent that's helping you with the paperwork, but they recommend that it's not, but it can be. A couple little things I wanted to point out about the Virginia laws was that for EMS, for example, if you're in a car crash or something where EMS is called to the scene first, in Virginia, EMS personnel are actually not authorized to follow an advance directive. The only way that they can do that is if they get a physician order for a DNR on the emergency scene, but otherwise the advance directive doesn't take place until you get to the hospital. Also, with the Virginia advance directive, like other states, Virginia will accept and recognize other states' advance directives. However, if you're a person, say for example, that lives half the year in Florida and half the year in Virginia, then you might want to think about getting an advance directive in both states, just so that your wishes will be known wherever you are in case something does happen to occur. Another point with the Virginia laws is that Virginia maintains a stupid fly. Virginia maintains an advance directive registry. And so that's not all states do that, and that's an important thing that Virginia does because that allows you to upload your advance directive so that it can be found at any time. Say you're in a car accident and nobody knows where you put your paperwork, so they don't know what your wishes were. It can be accessed by physicians, by family members. You just want to make sure you always keep that updated. Another important point for Virginia is what if you change your mind? What if you made this advance directive 15 years ago and now your wishes aren't the same? Well, the good thing is you can revoke a Virginia advance directive at any time by signing and dating a revocation, by physically destroying the piece of paper, by telling your doctor that you want to change it or you want to cancel it. So it's not a permanent thing, and what you decide 20 years ago may not be what you want now, so it can always be changed.
Okay everyone, that horn signals the end of the first round. What we'll do next is have the two winners, Kim and Emily, move on to our last round. During this round, they're going to discuss how the Patient Self-Determination Act affects PAs in their practice today.
Okay, Maddie, thanks. So, PAs as healthcare providers are practitioners of the science of life and also of death. PAs should be prepared and willing to discuss advanced directives with their patients. Death is inevitable. Nobody likes to talk about it, but it's going to happen. And PAs, as frontline providers and caregivers for the dying, should take a leadership role in educating the public, policymakers, and also patients themselves.
Yeah, another thing about that is the PAs actually have a responsibility to inform their supervising physician when there is a near-death planning, anything like that happening. And we have a ethical responsibility to the patient and the physician to do that. And a PA should never withdraw life support without a supervising physician's agreement on that. And you can see how this could put a PA in a difficult situation in, I guess, just between the patient and the supervisor. So the best thing to do is to discuss the end of life process with the supervising physician over any conflicts that could arise. And we have to remember that the physicians bear all the liability and have the final responsibility for making the clinical decision. And one more thing, if you feel that there's any legal or ethical issues going on, then you have to be responsible and speak out about that in an appropriate and timely manner.
You made some good points there. Another thing that I wanted to talk about was that PAs, they also need to recognize that dying is a personal experience, and it's going to be different for everyone. Everyone's an individual, and PAs must recognize that individuality and also diversity and not discriminate against that if their wishes and values don't match up. PAs also must recognize that their own values and beliefs with regard to pain and suffering and the process of dying can really affect the patient. And so the PA must make an effort not to project their own values and priorities onto the patient. Ultimately, it's the patient's right to choose. That's the primary. Ultimately, the patient's right to choose is primary, and patient autonomy is most important.
Well said.
I think that was some great discussion. I think after these 2 rounds, we can clearly say that Emily had some really good points and declare her our winner for today. I hope you all really enjoyed this episode of Around the Horn Shenandoah PA edition, and that you learned enough about Patient Self-Determination Act for you in the future. Thanks!
Another turning point, a fork stuck in the road. Time grabs you by the wrist, directs you where to go. So make the best of this test and don't ask why. It's not a question but a lesson learned in time. It's something unpredictable, but in the end is right. I hope you had the time of your life. So take the photograph.
Bing, bing. Ah, pew, pew. Did you fill out your advanced directive? Advanced directive? What is that? It's like a living will for when that missile launcher hits you. You idiot! I have healing powers. Maybe you should fill one out. Oh!